Hello and good whenever this is. Hope you're having a great day. Hope you're well. Um, Not legal advice. Like, subscribe, share, paint, show dogs, show cats, show plants. Hope everybody's well in this holiday season. I know for the MMTLP crowd, it's a year, and I'm there with you. 1 year. Happy anniversary of a bad anniversary. So, today I'm going to talk about a couple of Supreme Court rulings. I'm going to talk about a dismissal involving GTII, and I'm going to talk a little bit about MMAT. But of course, before we begin with that, I wanted to throw out a couple of things. I told my friend 10 jokes to get him to laugh. No, no pun in 10 did. The toughest job I ever had was selling doors door to door. And last but not least, I told my doctor that I had broken my arm in two places. She said, "Stay away from those places." Anyway, starting with the topics we just addressed, Supreme Court, two cases that were argued this week. One was a tax case involving a tax that was purportedly due over overseas investment income from India during a specific period of time. It was oddly taxed, despite the fact that the taxpayers never actually received the funds. And so the issue was that income for tax purposes? The bigger question is, and so that's what's being litigated. The government obviously has an interest in collecting tax money, so we know what they want. But if the Supreme Court rules against the government, what would be most significant is that would probably limit the government's ability to issue wealth taxes and those type of taxes, as has been suggested by some in the past. So that's the tax case. Again, some results sometime in June, and again, it's going to test what income is and when the government can tax, and we'll see the breadth of it based upon the court's ruling. The second case that I thought was really interesting that was argued this week was about Purdue Pharma, and if you recall, Purdue is the company in the Sackler family that introduced oxycodone as the safe alternative opioid. We know it ended up not being as such, and there may have been knowledge of that during times. And eventually, during a period of time, the family collected $11 billion just from the sales of those drugs. There was a big brouhaha based upon the number of fatalities that resulted. Lawsuits were filed. Eventually, the family and Purdue Pharma filed bankruptcy, and were able to establish a plan for payment of monies to injured and states, etc. And the plan from the Sackler family was $6 billion. So they were going to pay up to $6 billion. They had received up to $11 billion, and for giving up that $6 billion, they wouldn't get a full release, and it would apply to claimants that were not present in that particular proceeding. And this happened within a bankruptcy proceeding. So the question before the court was whether that release of those claimants who are not there, and generally the proceedings themselves, do they withstand constitutional scrutiny? And the question was, specifically, they looked through the rules, and it basically has to be a proper, appropriate provision. So the question is whether the release of these scumbags, Sackler family, is that an appropriate provision? So that's kind of the thing to be determined. And since it involved the opioid crisis, it's obviously of interest. I'll keep you apprised how those turn out. That obviously will happen sometime in before June also. Number three. So I've seen reference to GTII and the dismissal of a case involving spoofing. And JR and I did a couple of live streams where we talked about this. In fact, one of them I did a like 10 or 15 minute talk on this, and JR thought I was a little bit too much on that, which is interesting. So, but we've seen reference. And so the issue is what happened. We don't know because neither counsel or the company has indicated. But we know a dismissal was filed, and on that dismissal, it did reference that no Rule 11 sanctions would be asserted. And just to put it in its proper perspective, that was a spoofing action, and spoofing is different from counterfeiting, for example. So in a spoofing action, there's a bunch of elements that are required, and one of those is continuous damage. And the way it would work is you might have an expert who would come in, they would start doing the work, they'd make certain suggestions about what they could or could not prove, but they wouldn't have completed their work. And perhaps their support was necessary to win in the case. And sometimes it happens, you get an expert and they just don't work out. And so something you thought they were going to prove won't be proven. And Rule 11 basically is a federal rule. So if I am in federal court and I file something in federal court, I'm vouching that there's evidentiary support for what I'm stating, that there's basically legal support for it, or I'm making an extension of an existing case, and I'm not doing it to harass, etc. But if I don't have the factual background, then someone might be able to make a motion. If make the motion, they could seek sanctions, which would be, let's say attorney's fees against the client, and they could also do against the law firm. So that's available. So the way it works is perhaps you go into a case, you think you're going to prove it up. Perhaps things don't work out. At some point in time, if the defense sends out a particular letter, you have a period of time in which to respond by dismissing the case. If you dismiss the case with prejudice during that time period, then there are no monetary sanctions or repercussions that can go against the client or the attorney. So usually it's 20 days. So a letter's sent out and it gives you 20 days to dismiss. And if you do, then that's the end of the case, but no sanctions of any sort. So I don't know what happened in this case because I haven't heard from either party. But based upon my understanding of what happened in this case and my review of documentation, I feel pretty comfortable that was the conclusion. So there was a determination made that you couldn't prove up the spoofing case or one element of that. There probably was some type of Rule 11 letter. There was an agreement to move on, but all of this is completely unrelated to the counterfeiting claims. Again, it's just spoofing. So that's the kind of how I would read what went on, and I also based that on my own experience and the language itself on the dismissal that was filed. So that was a determination, and the client would have been consulted on that. Generally, what would happen on that, if you were going to dismiss a case or intended to, you would consult with the client, you'd fill them in on the facts. They would then say yay or nay. If they agreed, then you'd go ahead and do what you were going to do. And if they disagreed, you'd sub out counsel, find new counsel. So it appears that the client agreed with the decision. I don't know what the client was told about what the basis was, but that's my surmising of what went on and why the case was dismissed. Again, the determination that you couldn't prove up that particular claim involving spoofing, probably for some technical reason. Again, I don't have firsthand knowledge, haven't spoken to either counsel or the entity, but that's my good faith belief. And I try not to grossly speculate when I don't know. But it was a risk decision probably to avoid the potential risk of having to pay money. So that's my speculation, healthy speculation. And I hope that clarifies why the case would have been dismissed. And again, I haven't been informed by anybody, so it's just my determination. Last but not least is Mmat. I did see that Mr. Palikaris resigned from the board. I did reach out to Mmat probably February, March. I was concerned about their lack of involvement in the MMTLP dispute. I never heard back from them despite multiple inquiries. I think I reached out to Nextbridge at the same time, and eventually I did hear back from Nextbridge. But I elected not to pursue it with MMAT any further. I didn't think it was helpful to the community, notwithstanding it annoyed me, by the way, at the time. And when I saw that the GP was terminated, and they indicated that a week after, along with a bunch of other things, I wasn't a big fan of management. And in my opinion, I'm not. I don't trust management at this point in time, and I don't know what their aims are with regard to the particular stock. I'm sure somebody could buy the technology in a bankruptcy, and I think that's what may happen. And I got out of the stock, I think, at 21 cents after Palicaris was announced as leaving the company. But I have felt uncomfortable with management for quite some time, and that hasn't changed up till today. So that's MMAT. Last but not least, a year and still, and I addressed this at the beginning, but a year and still no resolution on MMTLP. All those guys in Washington should be embarrassed and should be flogged. Ridiculous. Anyway, be well. Hope that clarifies it. If you have any questions, further questions on what I said about GTII, post them in the comments and I will address them to the extent I can. Be well.